Hi guys, this is Erica from Gokce Capital. Now before I begin, be sure to click subscribe and turn on the notification bell. Patrick wanted to represent himself when he filed an application to probate his wife's estate. Yet the court told him he couldn't do this. So what happened? We'll find out at the end of this video. But first, if you must probate a loved one's estate in Texas, one possible way to reduce the time and cost of the process is by using a Muniment of Title proceeding. And in today's video, we have the top things you should know. Number 1. What is Muniment of Title? Muniment of Title is an expedited form of probate that allows the transfer of property without the need to administer the estate or assign an executor. In this video, we will focus on the state of Texas, since this is where Muniment of Title is primarily used. Number 2. What is probate? To understand what the Muniment of Title is, you must first understand probate. Now, probate is the process of determining ownership of property and assets owned by a person who has died. Probate is done for several reasons. It provides proof of ownership for the transfer of title to real estate or other assets. It allows the administrator or executor to pay off debts or eliminate creditors. And it provides a process to set aside assets for protected owners. Number 3. Normally, the probate process can take some time since a court must review the will and assign an executor or administrator. A Muniment of Title proceeding expedites this process. So what is required in order to probate using Muniment of Title? The requirements to approve a request to probate a will through Muniment of Title are as follows. The court must agree that there is a valid will. There must also be no unpaid debts except for mortgages or other liens attached to real estate. And finally, the court must rule that there is no need to proceed with full administration. Number 4, let's look at an example. Let's say Joe Smith passes away and leaves a valid will. His estate includes only a bank account and primary residence. There are no debts. Jane Smith, his wife, is a joint tenant on both the house and bank account. Jane may therefore be able to ask the court to probate Joe's estate as Muniment of Title. Number 5. Here are the top 3 reasons why someone may want to use Muniment of Title to probate a will in Texas. The first would be if the will has executor issues. This is to say that perhaps an executor was not mentioned in the will, or the named executor is dead, unwilling to serve, or otherwise disqualified. Since Muniment of Title does not require an executor, it can sidestep these problems. Of course, the primary benefit of Muniment of Title is speed. Probate, depending on how complicated the estate is, can take a long time. Alternatively, in some instances, a Muniment of Title proceeding can take less than 20 days. And finally, the process is simple. Number 6. When is Muniment of Title not recommended? Muniment of Title is often an efficient and cost-effective way of settling a small and uncomplicated estate. However, it's not recommended in all cases. Here's when you may not want to use it. If the estate contains significant assets, if the beneficiaries are hostile to one another, if some of the assets are held out of state, and if the estate has debts other than a mortgage. Number 7. Can I handle a Muniment of Title case on my own? Well, the short answer is no. It is not typically a good idea, as there are strict statutory procedural requirements related to the Muniment of Title process. As a result, you should hire a lawyer to assist. Which brings us back to Patrick's case. Patrick's wife died in Travis County, Texas on June 22, 2017. She left behind a valid will in which Patrick was named as independent executor and sole beneficiary. On July 11th, Patrick filed an application in which he requested that the court name him as executor of the will. At the court hearing in August, Patrick represented himself. When asked by the court why an administration was necessary, Patrick stated that there were assets located out of state and some balances on credit cards. Given these facts, it sounds like Muniment of Title shouldn't work, right? Well, it may surprise you to learn that the court ordered the will to probate as Muniment of Title. because someone representing a third party, such as an estate, cannot represent themselves, a decision that Patrick was not happy with. Now you may be wondering why Patrick was not content with the Muniment of Title order. Shouldn't he be happy that the court allowed him to go through the expedited process? Well, I should preface all of this by saying I am not a lawyer, but based on my experience, the fact that a full probate proceeding was not allowed could pose a problem if you wanted to dispose of the properties located in another state. This is because most states will require that you record the full probate proceedings in the county where the property is located if you want to transfer title cleanly. This is called ancillary probate. But what happened to Patrick? Sadly for him, the appeals court affirmed the lower court's ruling, stating that the court was unable to determine Patrick's suitability as an executor absent attorney representation. It seems it was time to hire a lawyer. But what do you think? Do you have any stories about probate or Muniment of Title proceedings? Let us know in the comments. Did you like this video? You're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in just 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down listings at gokcecapital.com/listings. Finally, don't hesitate to reach out. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.